Morning. I'm 30 seconds away.
Good. You sorted? Can I help at all?
Nope, you're all good. Yes.
Yeah.
Oh,
Yeah, it dims.
automatic.
It's 5 past.
Yes. Hi. Hi, guys. So, I have like 30 more seconds. So, in line with the faculty, what the faculty wants is that we're trying to get some more in-person feedback. And this is our best way to do it with a 400-person class. So, there's questions up here. At the end of this first half of the lecture, could you please pass your sheets of paper to this side of the room, and I'll come and collect your sheets of paper. Yeah? And I'll come grab it. You can just give it to me. You don't have to write your name on it. Yeah, that's it. As long as you number your questions, you're all good to go. Thank you.
Morena, everybody. Sorry, I should just put this on. Just talk among yourselves for a bit longer. I'll mic myself up. Okay. So we've been looking at the negligence cause of action when mental injury is the only damage that the plaintiff has suffered. And this is a necessary area because in practical terms, we can still sue for compensatory damages in this field, except for work-related mental injury of a narrow variety in Section 21B of the Act. So it's been necessary to revisit the common law of this in this area because the ACC scheme is not comprehensive. We've been looking at the nature of the actionable damage required, and we saw last time that although it is controversial, for the time being at least in New Zealand, a recognisable psychiatric injury is required, though there is some dissent from that, and in Canada, an alternative view which followed Justice Thomas's dissent in Van West is taken. Now we're looking at the elements of a duty of care in this category of case, this special category of case where there's this acute concern for the floodgates, particularly in secondary victim cases. And so for a sufficient relationship of proximity, certain special elements have to be established in addition to reasonable foreseeability of psychiatric injury. And in McLaughlin and O'Brien, Lord Wilberforce discussed those special elements. Remember the facts. A mother comes to the hospital some 2 years after a dreadful accident in which one of her children was killed, and she finds the other members of the family covered in oil and dirt and blood, and obviously very distressed. And the question is whether the House of Lords would approve what some lower courts had accepted as the immediate aftermath principle. In other words, that a mother who does exactly what you would expect her to do, to rush to the hospital to comfort and be with her family, it would be subsumed within recovery. So she doesn't go to the scene of the accident, she goes to a different place, and there's a time gap of some 2 hours. Lord Wilberforce's reaction was that as a matter of logical progression and justice, these facts, it would be fair to admit her claim and assimilate it within the aftermath principle or doctrine which the House of Lords approves in the interests of justice. He says, can it make any difference that she comes upon them in an ambulance or is here in a nearby hospital when, as the evidence shows, they were in the same place, in the same condition, covered with oil and mud and distraught with pain? But he did say, and it's repeated often in later cases, that he considered these facts at the margin of those passing the test. So clearly foreseeability alone is insufficient for this sufficient relationship of proximity, and he goes on to propose, in addition, various elements that the secondary victim plaintiff would also have to establish. And the first relates to the class of persons owed a duty of care, and this is known as relational proximity. And as to these, he said the previous cases had recognised claims by spouses by parents and children. They were within the established law, but by contrast, spectators, bystanders, were excluded, either because they're assumed to be robust enough to withstand injury, or that on the ground that the defendant cannot be expected to compensate the world at large. So the present law was justifiable, he said. He couldn't say that other relationships should never be admitted, but in the future, other cases involving less close relationships must be, quote, closely scrutinised. The closer the tie, he said, not merely in relationship, but in care, the greater the claim for consideration. The second element is proximity to the element. This, he said, the plaintiff's proximity to the accident must be close in time and space. To insist on direct hearing or eyesight of the accident itself, he considered would be impractical and unjust. And so this case does extend recovery to the immediate aftermath, where the plaintiff comes very soon onto the scene and witnesses the horror in the hospital. Thirdly, he talked about the means of communication. And this is to say that there had been no case where a plaintiff had been told the bad news by a third party. Initially, if the plaintiff hears about the accident from a third party and hurries to the scene or to the hospital, as Mrs. McLaughlin did here, that's enough. But the shock must come through direct perception, either sight or hearing. It's clear that he has in mind that these three elements will be balanced against each other. They won't necessarily be determinative. So a weaker case on one of them, so for example, relational proximity, maybe the plaintiff is only a sibling, might be able to be overlooked by stronger facts on one of the others. Very strong physical proximity to the accident, or a particularly shocking accident, for example. Immediately after McLaughlin and O'Brien, there was an Australian case called Janich and Coffey in 1984. I don't think I've got a slide on this, no. Very similar facts, and it was held the same way. It involved a wife who rushed to the hospital where her husband, who'd been on a motorcycle in an accident, had been taken by ambulance. And she witnessed harrowing scenes both before and during the 3 operations that he had throughout that night. She went home. She was called back to the hospital to say, with the news that he was very bad and she should be in the hospital. And she didn't know, for some 3 weeks whether he would survive. And the House of Lords and the High Court of Australia, extended the aftermath to the hospital to which the direct victim was taken during the period immediately after the accident and for as long as the plaintiff was in the hospital for post-accident treatment while the victim remained in the state produced by the accident. So Lord Wilberforce's those 3 elements of proximity have shaped the UK law in this area. And we'll look at them at work in the next House of Lords decision, the Alcock case. But before Alcock, let's just locate ourselves in the context that the Hillsborough disaster occurred in. So McLaughlin was decided in 1983. The 4-year period to 1989 has been referred to as the UK's disaster era. A large number of man-made disasters occurred during that time, and some of them are listed on this slide. Many of these disasters gave rise to large-scale litigation. Some of it focused on psychiatric injury, but most were settled in out-of-court settlements or arbitrations. There were few mental injury cases that made it to the courts, and none until the Alcock case made it to the House of Lords. So this case arose from the tragic Hillsborough Football Stadium disaster in 1989. The negligence alleged, which was admitted for the purposes of the case that you've got in your reading, was the police's negligence in controlling the crowds. The immediate cause of the disaster was a senior police officer's decision to open an outer gate to the stadium without first cutting off access to 2 sections which were already full. And it allowed a large number, an excessive number of spectators to enter those sections. And a terrible tragedy ensued where the crowd essentially stampeded. 95 people were killed, 400 injured in the stampede of spectators that took place. So breach of duty is admitted for the cause of the Alcock case in the House of Lords, and causation between the negligence and the psychiatric injury is also admitted for the purposes of the case. By all accounts, this was a horrific and unimaginable tragedy. 10 plaintiffs who are in the appeal weren't themselves injured or in danger, but they alleged that the impact on them of what they saw and heard caused them severe shock and psychiatric illness. To recover, remember, plaintiffs can't build on a wrong to their relative, the primary victim who died or was injured. They have to show an independent duty of care owed by the police to them. The 10 plaintiffs were representative of various factual permutations. Some witnessed the tragedy from other parts of the stadium. Others were watching the events on live TV or listening to it on the radio, or they entered the ground to search for a missing relative. They later learned of the death of their relative either by being told about it or, in one case among the plaintiffs, identifying their loved one's body at the mortuary many hours later. Standing behind these 10 plaintiffs were about 300 others whose claims waited to be settled in light of the principles that emerged from the case. The plaintiffs argued that the test for liability for psychiatric injury is or should be reasonable foreseeability of psychiatric injury. And Lord Wilberforce's 3 elements of proximity were merely considerations that should be taken into account in deciding the reasonable foreseeability test. They weren't separate elements, they weren't determinative. Alternatively, they sought to extend those elements in various ways. So what did the House of Lords hold? So The law in this field is shaped by, certainly in the UK, by a distinction between primary and secondary victims, which I've referred to already. And there's Lord Oliver's definition of primary and secondary victims. Those cases in which the injured plaintiff was involved either mediately or immediately as a participant is a primary victim. Those in which the plaintiff was no more than a passive and unwilling witness of injury caused to others is a secondary victim. And this case is about secondary victims. The primary victim cases were not helpful, he said. Now, that definition we shall see in the Frost case we'll look at in a bit is controversial and it is later revisited. There's much less of a concern with the floodgates in primary victim cases. There's a fixed number of primary victims, but there can be a very wide circle of secondary victims. And so Lord Wilberforce's elements that we looked at in McLaughlin apply only in secondary victim cases. And the reason is because of the concern of opening the door too wide, the floodgates. So, unsurprisingly, the House of Lords rejects the plaintiff's argument that liability for psychiatric injury should be determined simply by reasonable foreseeability of psychiatric injury. The three elements, Lord Wilberforce's three elements, are determinative, they're fixed, they must be satisfied, the House of Lords says, in this special category of case. So, coming to those elements, first, the relational proximity. Generally speaking, the House of Lords said, the secondary victim must show a sufficiently close tie of love and affection to the primary victim. Those plaintiffs that Lord Wilberforce had talked about, spouses, children, and possibly engaged couples, this is some time ago now, there's a rebuttable presumption of a sufficiently close relationship. So the plaintiff doesn't have to produce evidence that the relationship is indeed a close one. Although a defendant it would be permitted for a defendant to produce evidence to the contrary. For example, to show that a father and son are estranged, for example, unpalatable though that thought might be. But aside from those relationships, the plaintiff must produce evidence that the relationship is a loving relationship, similar, akin to a parent or a spouse, before they'll be able to recover. So if you can't show this, it's unlikely that you could recover for psychiatric injury. So there were two claimants at the stadium itself. One lost two brothers and the other a brother-in-law. The House of Lords said these were ordinary brotherly and brother-in-law relationships, not enough. They hadn't produced evidence that this was a sufficiently close relationship. No duty was owed. So given this idea, given relational proximity, it's very unlikely that mere bystanders to an accident suffered by strangers would be able to recover. But Alcock left open this possibility, suggesting that if the accident was particularly horrific, this element possibly might be met. But a later case, at the bottom of the slide, McFarlane against E.E. Caledonia, the Court of Appeal in Britain, rejected that idea. This involved an explosion on an oil platform, killing 164 men. And the claimant, was on a vessel that came to assist and couldn't show a relationship of love and affection and could not succeed. Note, our Supreme Court hasn't ruled on relational proximity. Proximity in time and space. The plaintiff must be close to the accident, both in time and space. At one end of the spectrum, you've got a plaintiff who suffers psychiatric illness after being told the news by a third party, not able to recover. At the other end of the spectrum, the plaintiff is actually present and sees the horrific tragedy unfold, clearly satisfied. In the middle, you've got the immediate aftermath. Whether the plaintiff falls within the immediate aftermath will depend on how quickly they can get to the scene of the accident or hospital, and the state of the victim when they arrive. So a claimant who viewed the damaged and bruised body of his brother-in-law, who had been crushed at the mortuary some 8 hours later, was not able to satisfy this second element. And Lord Jauncey noted that the purpose of the visit to the mortuary was identification rather than comfort and care, as in McLaughlin. So it seems perhaps that the purpose of coming across the aftermath might be relevant also. This all seems extraordinarily arbitrary, doesn't it? And that's the problem with any line drawing at the boundaries. Is the trauma any the less because the plaintiff sees the loved one's corpse after 8 hours than after 2 hours in the hospital? Liability might depend on chance things like how many victims there are, how far away the secondary victim was from the accident scene, how efficient the relief effort was, the state of public transport, for example. But Lord Oliver says, and there's the quote at the bottom there, the ultimate boundaries of legal liability in these cases have to be fixed not in logic, but in the end upon considerations of policy. We'll see when we look at the Australian cases next time that Australia has gone in a very different direction to this. The means of perception of the shock, this is very much connected to the second element. Lord Wilberforce said it has to come through sight or hearing of the event or its immediate aftermath. And the question here was, what about those plaintiffs who viewed the events on simultaneous TV broadcast? Two parents and a fiancé who satisfied relational proximity watched the events unfold on television. They didn't know whether their son and fiancé were at the game, or they knew that they were at the game, and the fiancé knew that her partner was in the Leppings Lane end where the tragedy occurred. But the House of Lords held that there wasn't the necessary degree of proximity for a couple of reasons. The code of ethics that applied to television broadcasters at the time required that scenes of trauma, and particularly identification of victims' faces, not be shown. And so faces were pixelated, traumatic scenes weren't shown. And so the pictures didn't provide the degree of immediacy required to found a claim of psychiatric illness. The House of Lords said the trauma arose from seeing the broadcast, but also partly from confirmation later of the death of the loved one. That wasn't enough. So the test seems to be whether it's equivalent to actually being at the scene or the aftermath. The shock must be caused by the equivalent to actual sight or hearing of the event or its aftermath. And that wasn't the case here for those reasons. There were several other elements that the House of Lords erected as barriers as well, which we see discussed in the later cases. This fourth fact, that the psychiatric injury must be shock-induced, caused by sudden shock. And there's Lord Ackner's quote there. A sudden appreciation by sight or sound of a horrifying shock doesn't include psychiatric illness caused by the accumulation over a period of time of more gradual assaults to the nervous system. So this element becomes controversial, and we will see that this rather arbitrary rule is abandoned later in Australia. In the UK, it came to be very stretched in the case law, so that ultimately it was abandoned in the Paul and Wolverhampton case that we'll be talking about later. Okay, the next case is Page and Smith. This was a primary victim case, not a secondary victim case. The facts involved a minor car collision in which the plaintiff's car suffered damage, but he didn't suffer any injury at all. He could, in fact, drive his car away from the scene. Not even bruised by his seatbelt, literally no injury. But 3 hours after the accident, he felt exhausted, and that exhaustion continued, and he suffered his chronic fatigue syndrome, which he had suffered intermittently over the years, manifested itself after the accident so as to become chronic and render him unable to work permanently. And he's suing the defendant driver of the car. Prior to Page and Smith, it was generally understood in all the cases of psychiatric injury, whether primary or secondary, that there was a very specific remoteness requirement applicable in those cases. Remember, in physical injury cases, the remoteness rule is the eggshell skull principle. You take your victim as you find him or her. In these psychiatric injury cases, another barrier had been erected through this very specific remoteness rule, the opposite of the eggshell skull principle. It was considered necessary for the plaintiff to demonstrate foreseeability of psychiatric injury in a person of ordinary fortitude or vulnerability. So there was this ordinary fortitude qualification. It wasn't a requirement that the plaintiff had to be a person of ordinary fortitude to recover, but in determining whether psychiatric injury was foreseeable, if the plaintiff was unusually anxious or had suffered from previous mental injury, was predisposed in some way to psychiatric injury, the injury would be unforeseeable and too remote if a person of ordinary fortitude would be able to withstand the shock without psychiatric injury. This is the weird and wonderful world of mental injury that we're in. This was a control device, clearly designed to limit recovery. It might be different if the defendant knew of the plaintiff's previous susceptibility, if the defendant had special knowledge and was aware of that vulnerability, the remoteness rule might not apply. So in this case, the Court of Appeal held that it wasn't foreseeable that a minor car collision such as this, in which the plaintiff was harmed, could cause psychiatric injury to a person of ordinary fortitude. And so the plaintiff couldn't recover. Case comes to the House of Lords on appeal. And the House of Lords allows the appeal in what is a very controversial case. They held that victims who were at risk of physical injury in an accident, for them, for primary victims, who were at risk of physical injury, it wasn't necessary to show reasonable foreseeability of mental injury at all. It was enough if personal injury was reasonably foreseeable, so some kind of physical injury. So first off, they altered the test of reasonable foreseeability of psychiatric injury to say, no, you only have to, some kind of personal injury, usually physical injury, has to be reasonably foreseeable. And then they said the eggshell skull principle applies. You take your victim as you find him or her. So this was a very expansive holding for primary victims, so that all primary victims in the UK had to show was reasonable foreseeability of personal injury. So as I say, this controversial decision, ignored in Australia, rejected in Canada, went on to cause all kinds of problems in the UK, as we'll see. So, any comments? What do you think about this ordinary phlegm principle, ordinary susceptibility? Is there such a thing in our in our pluralistic society? Can we identify a person of ordinary phlegm? Is there such a thing?
Oh, I think nobody can identify a reasonable person.
Right, yeah. Same issue arises. Nice, yeah. We'll see that in Australia this principle has been disposed of. Courts are trying to reach some idea, aren't they, that there are some calamities in life with which those which fall within kind of part of the vicissitudes of life that we should all be able to withstand without suffering psychiatric illness and suing for them. Okay, there are 3 more British cases to go, and then we'll be able to turn to the Australian cases. The next case is Frost. Now, this was the next stage of the Hillsborough disaster. This time, police officers who were on duty on the day and assisted with the tragedy, who suffered post-traumatic stress disorder, sued their employer, the chief constable, arguing that he was vicariously liability for the negligence of the senior police officer. These police officers were never in any physical danger, nor did they consider themselves to be in danger. It was it was the overwhelmingly horrific nature of the events which caused their PS, post-traumatic stress disorder. So the first question that the House of Lords had to consider was, are these people primary or secondary victims? If they were secondary victims, they would have to meet the, I'll call them the Alcock criteria, the 3 elements of proximity. And they couldn't show relational proximity, a close tie of love and affection with any direct victims. So in order to recover, they had to show that they were primary victims, and they argued that they were rescuers. Now, liability to rescuers had been recognised in previous case law, in particular a case called Chadwick, which I'll come back to in a minute. They said, we were actively involved in giving assistance in the aftermath of the tragedy. In these harrowing circumstances, we were rescuers, we should be treated as primary victims. And they invoked Lord Oliver's definition of a primary victim that I put up in the slide for you from the Alcock case, of being involved in being a participant in the events. And as I say, they relied on this 1967 Chadwick against British Transport Commission case. This involved a Mr. Chadwick, who was apparently quite a small and agile man, who crawled, this was a train wreckage, and he crawled into the wreckage, bringing aid and comfort to the trapped passengers after the Lewisham train disaster. It turned out that he was in physical danger from time to time, but he wasn't aware of that. He recovered for his psychiatric injury as a result of the horror of the whole experience. And that decision had been approvingly cited in Alcock and in McLaughlin, and the plaintiffs relied on it. A majority of the House of Lords held that for the purposes of recovery of damages for psychiatric injury, rescuers aren't a special category of case. They have to conform to the rules of primary and secondary victims. They're not given special treatment. So they had to meet as a threshold the ordinary definition of a primary victim. Lord Stein adopted a narrower definition of a primary victim than Lord Oliver's definition in the Alcock case. He adopted some words of Lord Lloyd's in Page and Smith, in which Lord Lloyd had described a primary victim as a participant directly involved in the accident and within the range of foreseeable physical injury. So this definition of primary victim was significantly narrowed. Lord Stein essentially converted it into one who has objectively been in physical danger or reasonably believed themselves to be in physical danger. So it's a danger qualification. Anyone outside that definition is a secondary victim. So this is a new control device limiting recovery. It doesn't mean that the danger has to be the cause, or the perception of it has to be the cause of their psychiatric injury. It's a sort of a threshold requirement, providing the person was exposed to personal danger or reasonably felt themselves to be, that's enough. So for Mr. Chadwick, he was at times exposed to danger, but his injury was caused by the whole horrific set of circumstances, and that case was still rightly decided. So because none of these police officers were at any time exposed to danger, nor perceived themselves to be, They were secondary victims. They were subject to the Alcock criteria and couldn't recover. There's a real policy consideration acknowledged in the judgment which drives the outcome in this case. It's a concern about distributive justice, treating plaintiffs equally and fairly. Alcock had denied recovery to bereaved relatives, and it was felt by the House, the majority of the House, that allowing recovery for paid police officers but not to bereaved relatives would offend most people's sense of justice. And so the holding that rescuers are to be treated the same as everybody else. So Lord Stein said, if the police officers could recover, it would introduce an imbalance in the law of tort which might perplex the man on the underground. That seems to be the equivalent to the man in the Clapham omnibus. The second concern driving the outcome in these cases, you see the House of Lords trying to find reasons to deny recovery. And they're really concerned about the floodgates in particular. And so Lord Stein, in his judgment, basically sounded the call. The law had gone thus far and will go no further. They were drawing a line. They described the recovery of compensation for pure psychiatric harm as a patchwork quilt of distinctions which are difficult to justify, and proposed that there could be two solutions to this very unsatisfactory situation. He said one solution is what Jane Stapleton had, a torts writer, well-known torts writer, had suggested, and that was to completely abolish recovery for pure psychiatric harm altogether, so that you didn't get these very unpalatable distinctions. The second one at the other end of the spectrum, and this is the approach taken in Australia, we'll see, is to abandon the Alcock criteria and all the other restrictions and place recovery for psychiatric injury on the same footing as that for physical injury, so that psychiatric injury would be recoverable on the basis of reasonable foreseeability of psychiatric injury. Change, however, would be a path for government, Lord Stein suggested. At the time, there was a Law Commission report suggesting that legislative resolution of this mess was required, but subsequently the legislature has said, no, we're not going to change the law, we're going to leave this area for courts to develop. So the courts have persisted in trying to give content to this sufficient relationship of proximity. They haven't taken either of those two courses in the UK that I have described. Lord Gough, at the bottom there, issued a compelling dissent and adopted the definition of Lord Oliver in the Alcock case, wouldn't have the danger qualification to the definition of a primary victim. He said, what if you had two brothers working on the Lewisham train disaster, one in the front of the train and one in the back? One faced danger and the one in the back didn't. Each suffered post-traumatic stress disorder as a result of the harrowing scenes. One could recover, the other could not. He said this is arbitrary. The wider definition of primary victim suggested by Lord Gough has found favour in a later House of Lords case. Well, he didn't actually adopt Lord Gough, but a wider definition, as Lord Gough had suggested a wider definition should be adopted, was adopted in the W and Essex case. So it may be that a wider definition of primary and secondary victims may yet be accepted in Britain. The facts of this case were that the parents were foster parents and they had expressly requested that the defendant county council and social worker not to send them any child with a history of sexual abuse. And they received that general assurance that no sexual abuser would be placed with them. The council nevertheless placed a child with that history without advising them, and he went on to commit serious acts of sexual abuse against all 4 of their children. After discovering this, the parents were consumed with guilt for bringing him into their home, and they suffered psychiatric illness. Their previously happy marriage broke down. Both were unable to work. Basically, the whole family imploded. Awful case. This was a strikeout action before trial, and the House of Lords refused to strike out the claim on the ground, as the defendant argued, that there was no duty of care. It didn't matter. They said that the plaintiff's claim didn't fit clearly within the primary-secondary divide as set out in Frost. So it didn't matter that they weren't in physical danger themselves. It also didn't matter that they didn't come across the immediate aftermath. The means of perception of the shock was not what they saw, but what they heard. Lord Slynn delivered the majority judgment and said that the categories of primary and secondary victims are not finally closed. The law was still developing. And it was arguable that psychiatric harm flowing from knowledge that the person here, the parents, had brought the primary victim and the abuser together from feelings of responsibility or guilt, that he didn't detect what was happening earlier, was sufficient involvement in the incident to qualify that person as a primary victim. So there is the quote from Lord Slim in the Essex case on the slide. So this is the House of Lords then loosening the definition of primary victim, permitting someone who has a feeling of responsibility or guilt for what happened to be within the scope of a primary victim. Even if they were secondary victims and had to satisfy the Alcott criteria, Lord Slynn felt that the concept of the immediate aftermath has to be assessed in the particular factual situation. He wasn't persuaded that the parents must come across the abuser of the abused at the time or immediately after the sexual abuse. Okay, that brings us to the Paul and Wolverhampton case, which we'll start straight after the break.
Would I be able to put the questions back up
Yep,
during
go
the break?
ahead.
Thank you. No, it's all good. I would just steal the mouse.
Okay. Hi.
Just a question around the sort of the means by which you discover the injury again for the second offence. What do you think sort of the approach would be now that sort of at like FaceTime, it's going so complicated? You know, if someone is in that state, a very natural reaction would be, you know, call your partner, call someone who's
Yep.
not there
Yep.
via FaceTime, which sort of creates that, you know, almost like they are present.
Yep, yep, yep. And videoing and posting all this sort of stuff. Yeah, exactly. Yeah,
It seems to expand
yeah,
a lot
yeah, yeah.
and makes that,
Well,
that really sort of,
I mean, we'll see that the Australians have disposed of that and said, for that's exactly that sort of reason. That I mean, in the UK, the test seems to be that is it the same as actually being there? And because it was on live TV and because of the code of ethics, it wasn't. But the more you can argue that it was equivalent to actually being there, the more likely, it is that you will be able to recover. But even, so that's on the British approach, but we'll see in the Australian approach, they're much less so. And they've just moved to a position where the main question they ask is psychiatric injury reasonably foreseeable? And all those sorts of factual situations go to answering that question, whether it's reasonably foreseeable or not.
do we still require, not the reasonably foreseeable, but it's just like, right? You know,
Yep.
we were talking earlier
And
about
Pages Smith said it was only
physical, you know, personal,
four primary victims.
Oh, okay.
Yeah, yeah.
not second.
Not secondary victims. Yeah, yeah.
Okay. Because that seemed a lot confusing. It was like, we talk about, you know,
Yeah.
personal injury overall,
Yeah.
but then, of course, if you're a primary victim,
Yeah.
then
Yeah.
there's less likely because the indicator.
Yes, that's right. So everything is much stricter and tighter. They're looking for reasons to push the cases away, to deny recovery.
That's
Yeah. Okay.
Thank you so much, Joe.
Cheer. Okay. We'll start again. Thank you. One of the Australian cases that we'll be looking at, well, actually the key Australian case is called Annette's or Tame. There are two plaintiffs in the case, appeals heard together. In that case, the defendant, the wife of the defendant's station owner, had given assurance that the primary victim would be taken care of and looked after. And that was a key fact, as we'll see, that the High Court of Australia emphasised in holding a duty of care in that case. And they cited this case, W and Essex, and referred to the pre-existing relationship between the council and the social worker and the parents, whereby the parents had asked the social workers to assure them that they wouldn't place a child with a history of sexual abuse with them. That, they'd made a representation that they would not do that. And that kind of links to those ideas of assumption of responsibility that you looked at with Anna in the economic loss cases. And so they refer to, in the approach to duty of care in New Zealand, they refer to balancing of pro-plaintiff and pro-defendant factors. And so this idea of there being a special feature in the relationship, a pre-existing relationship between the plaintiff and the defendant, assurances given by the defendant, can be a strengthening factor pointing to a duty of care. So that's a more flexible approach than the British approach of just saying, is it a primary and secondary victim, and then going through the Alcock criteria to see whether or not they're satisfied, so as to contain as far as possible the circle of potential plaintiffs. Okay, the final British case that we look at is this decision in 2024 of the Supreme Court of the United Kingdom in Paul against the Royal Wolverhampton NHS Trust case. So these are three appeals being heard together, in which family members claimed for their psychiatric injury suffered when they witnessed their loved one's injury or death as a result of the NHS's negligent treatment, whether a failure to diagnose or to treat the primary victim. So these are the fact situations. In the Paul case, Mr. Paul was shopping with his two daughters when he had a heart attack, collapsed and died. 14 months earlier, he had been admitted to the defendant hospital complaining of chest pains. He had been treated and discharged, but the hospital didn't arrange for certain tests to be carried out on him, which would have revealed that he did in fact have significant heart disease, which, if detected, would have been treated. In the Polmere case, Esme Polmere, aged 6 years, had strange breathing episodes. A hospital paediatrician carried out testing on her and wrongly concluded that her episodes were related to exertion and were not in fact epilepsy, and that there was an underlying heart condition. A year later, she died at school in the company of her parents as a result of that heart disease. Evelyn Purchase died of severe pneumonia, aged 20 years. Just 3 days before she'd gone to an out-of-hours medical clinic with her mother, where the doctor failed to diagnose her chest infection. On the day of her death, her mother and sister went out to an event which they had purchased tickets for, and they came home to find Evelyn motionless in bed. Her skin was slightly warm, she looked alive, and she had the house telephone in her hand. They dialed 999, and the caller advised that they give her CPR. But when they opened her mouth in order to attempt mouth-to-mouth resuscitation, blood and bodily fluids spilled out. Pretty grim, isn't it? The paramedics arrived soon after and pronounced her dead. So here we have close ties of love and affection by the secondary to the primary victim, satisfying relational proximity. We have temporal proximity to the death. But unlike the earlier cases we've looked at involving secondary victims, these cases didn't involve some kind of horrific accident, such as a road accident or an event like the Hillsborough Stadium disaster. Instead, it involved a failure by a doctor employed by the NHS to diagnose a life-threatening medical condition suffered by the primary victim. So a case of medical negligence. And later, the secondary victim witnesses the family member having a medical crisis, their death of their relative, or it could be not these fact situations, but their injury as a result of the doctor's negligence. So, this proved fatal to the claim. Oop, what's that? Oh, yeah. Right. That's the one I want. Yeah, this was fatal to the claim. So the ratio of the Paul case is that there must be an accident, which is an external event which causes or has the potential to cause injury, the Supreme Court said. This is in the majority decision of Lord Leggett and Lady Rose. And the plaintiff must be present and directly perceive the accident or the aftermath, the immediate aftermath to the accident, not the later injury. So they said the accident is not the injury caused by that accident or event. Witnessing injury caused by the accident is not sufficient, they said. So there has to be an external traumatic event, although put a line through traumatic, we'll come to that in a minute, an external event or accident, and direct perception of that event or its aftermath by the claimant. So where the context is a medical crisis, as in these cases, and the plaintiff sees or remains with their relative, say in the hospital room, and witnesses the injury resulting from medical negligence, the plaintiff cannot recover due to the lack of any accident. How do they think this stuff up? So there were various things that they cleared up, various points they clarified, various things they said you don't need to show as a plaintiff. First off, it doesn't matter if there's a gap in time between the defendant's negligence and the accident, so long as there is a causal relationship and there is an accident which causes the claimant's psychiatric injury. Nor does the accident witnessed by the claimant have to involve the first manifestation of damage to the primary victim. That can come later. That would, quote, create unprincipled and complex factual disputes. It would be unworkable. So it doesn't matter if the claimant suffers injury later. The Supreme Court approved the case in Taylor against Anovo UK Limited, the third bullet point on that slide. It's a Court of Appeal decision in 2013. In that case, the plaintiff's daughter didn't see the accident at work that occurred to her mother and injured her, in which a stack of boards fell on top of her due to the employer's negligence. Nor did she see its immediate aftermath. But she was present when unexpectedly her mother collapsed and died at home 3 weeks later due to a pulmonary embolism. The case, the Supreme Court said, was correctly decided for the reason that the claim could not succeed because the claimant wasn't present at the scene of the accident or its immediate aftermath. There was no temporal or spatial proximity. The event, the injury, the death which she witnessed was not the accident. So the case was correct. This is interesting. The majority possibly left a crack in the door open. Can there ever be an accident in a medical crisis case? And the majority said, the question was raised in argument of whether the rules governing claims by secondary victims arising from accidents could ever apply in a medical setting. The question does not arise in the present cases. Various hypothetical examples were, however, posed in argument, such as a scenario where a doctor injects a patient with a wrong dose or a wrong drug, inducing an acute adverse reaction which is witnessed by a close relative. In our view, the issues raised by such examples are best left to be addressed in a case where they actually arise on the facts. So, possible chink in the armour there, where the accident and the injury occur at the same time and the relative is present. I don't know, doubtful. But certainly, as a matter of principle, it's hard to draw distinctions between road accident cases and medical accidents, but they seem to want to do that, to draw that distinction, to stifle as much as possible liability to secondary victims in medical negligence cases. They give lengthy reasons in the case, if you read it, for the decision. The main reason is that the ratio gives a clear answer to factual situations and gives legal certainty. But in addition, the ever-present floodgates is cited and relied on in the case. They cite concerns about opening the door to all claims in which direct perception of symptoms of a medical condition, however mild, could be considered as within the scope of recovery. But I think also that an explanation is that the Supreme Court, and in Britain they are adopting a particular lens that they're looking through these cases of psychiatric injury through. It's easy to look at the case law and say, these are arbitrary distinctions. How can it be that a mother who comes along to the hospital and sees her family covered in mud and blood and in, with cries of pain, be able to recover, but one who comes along 8 hours later because she has to fly in from another city cannot recover? Isn't the impact just the same if her family are in a similar condition, for example? So the rules seem arbitrary, and the lines drawn can always be criticised as unjust. But the Supreme Court, I think part of the explanation is that they are looking at the psychiatric injury cases as exceptional cases of liability. The general common law rule was always that the death or injury of a human being could not be complained of as an injury by another person, a dependent or a relative. On the ground, the reason for it was that a person does not have any legally compensatable interest in the physical well-being of another person. So the only person who could complain of death or injury was the person themselves. There was the Fatal Injuries Act UK, which allows dependents to sue, is a statutory exception to that common law principle. And these claims for psychiatric injury by secondary victims are a second exception to that general rule, that third parties cannot complain of the death or injury of another person. So if you view it as an exception, then it should be a confined category. So I'll just read you this section. Actually, it's from the start of the case. The majority. And I think this explains to some extent the British approach, that these psychiatric injury cases are an exceptional category and so should be confined. We all die, and when we do, the fact or manner of our deaths may cause harm to other people. Often such harm is readily foreseeable. We all know that the death of someone's child or of their partner or of a young child's parent will cause grief and suffering and can have prolonged and profound effects on physical and mental health. Death may also have dampening, even ruinous financial consequences for family members or others who were dependent economically on the deceased. Under the common law, the rule was that, quote, in a civil court, the death of a human being could not be complained of as an injury by another person. This is still the general rule. The same rule applies where the victim does not die but is severely injured. Essentially, the common law does not recognise one person as having any legally compensable interest in the physical well-being of another. The law affords compensation to the victim, but not to others who suffer harm in consequence of the victim's injury or death, however severely affected they may be. There's a statutory exception introduced by the Fatal Accidents Act 1846, now contained in the 1976 Act, which gives certain dependents of a person whose death is caused by a wrongful act, neglect or default the right to sue and recover damages from the person who, if death had not ensued, would have been liable to the deceased. There is a further paragraph 4, limited category of case recognised by the common law, in which damages may be recovered for personal injury consequent on the death or injury of another person. In these cases, it is not the death or injury of that person itself or the defendant's responsibility for it which gives rise to the claim, but the fact that the claimant has witnessed the wrongful death or injury or threat of such death or injury to someone they love. The scope of this category of cases is the subject of these appeals. So that's the particular lens they're looking at, that this is an exception to a general rule, and as such should be a confined exception. I think that in large part explains the myriad of rules that have been erected, that and the floodgates concern. Other points clarified by the Supreme Court in the case. As I indicated in the last lecture, they saw the lack of wisdom in the sudden shock rule and have also abolished it, as Australia did earlier. So the mental injury doesn't have to be caused by a sudden shock. This is paragraphs 73 and 74 of the case. It's enough for a claimant who was present at the scene of the accident or its aftermath, in which a loved one is killed or injured, to show that there's a causal connection between witnessing that event and the illness they later suffer. I think you can take it from this that the mental injury does need to be caused by the witnessing the event rather than, for example, the plaintiff being worn down by caring obligations of the primary victim as a result of the event. So the causal link has to be established. Another thing they clarified, no need for an objectively horrifying event. There's no such formal requirement. Cases prior to this had often used the phrase objectively horrifying event or traumatic event or harrowing scenes. This is not a formal requirement. The majority in Paul said, it is of course necessary for a claimant to show that it was reasonably foreseeable that the defendant's negligence might cause her injury. If, for example, a claimant with a history of psychiatric illness develops such an illness after witnessing a minor accident in which his wife sustained some cuts and bruises, his claim might fail that test. Here's the reason why they don't like the sudden shock rule. There's no available Richter scale of horror. The test pushes judges to compare the facts of the case before them with the facts of other cases and engage in an exercise of deciding whether or not the facts are similarly horrifying. So the sudden shock rule binned. Another unsatisfactory development, which they disapprove of, has been the emergence of a legal test of whether what the claimant witnessed should be regarded as one discrete single event, in which case the plaintiff can recover, or a series, an accumulation of separate events over a period of days in which they could not recover. So the paradigm case was North Glamorgan NHS Trust and Walters. Mrs. Walters' infant son died following 2 days of illness, which she witnessed. She was sleeping in her son's hospital room when he suffered a major seizure. He died. He was transferred to another paediatric hospital, specialist hospital, and died in her arms 36 hours later. Appropriate treatment had been delayed as a result of his misdiagnosis. And the hospital admitted that the baby had died as a result of its negligence. The key issue in the case was whether what happened to her was caused by, quote, this goes back to Alcock, a sudden appreciation by sight or sound of a horrifying event, as opposed to an accumulation over a period of time of more gradual assaults on the nervous system. That distinction had been drawn by Lord Ackner in Alcock's case, and it caused the case law to go off in this direction. Was this a sudden shock caused by one event, or was it a series and accumulation of separate events? A gradual process and accumulation was not recoverable. In the case, the court was clearly sympathetic to the claimant and held that the whole 36-hour period could be regarded as one horrifying event. But other cases with similar facts had fallen on the other side of the line. The Palmer against Tees Health Authority case on the slide there, which involved the abduction and murder of a child over a 6-day period, was held not to be one single discrete event, but rather an elongated process, beginning with receipt of the information that the daughter was missing and ending with her identification. 6 days was not sudden. It involved an accumulation, a series of events. So this kind of bizarre dividing time into discrete events or a single event, kind of very unscientific, isn't it, if you think about it? There were other vigil cases involving a number of days, 4 or 5 days, which were held to be on the other side of the line. So, fair enough, the Supreme Court calls these cases out and says there's enormous inconsistency in the outcomes, there's no coherent test of what counts as a single event. They also led to the extension of the aftermath, the immediate aftermath of true accidents to a period far beyond what was contemplated by Lord Wilberforce in McLaughlin and O'Brien. So there's no such requirement of a single event. Lord Burrows in in the Paul case, dissents and says, in his view, there does not need to be an accident at all. Witnessing the death or injury of the primary victim was the relevant event. And once that was accepted, liability could follow because psychiatric injury was reasonably foreseeable and the Alcock criteria were satisfied. There's a strange spelling of persuasive there on my slide. So all this, of course, is up for grabs in New Zealand. The Van Zer West case, our latest case in 1999, is a medical negligence case, a so-called medical crisis case. How would that be decided after the Paul case? Certainly, so Supreme Court decisions in the UK are persuasive, and majority decisions are more persuasive than dissents, but the issues are certainly up for grabs in New Zealand. All of this is completely arguable. Okay, so what's the state of the play in Britain? Primary victims. So for primary victims, if they wish to recover for pure mental injury, of course they have to show a medically recognisable psychiatric injury. The definition of a primary victim is someone who is at risk of injury, in danger, or reasonably apprehends themselves to be in danger. But query whether there's some flexibility, some movement here. W against Essex County Council. To show a duty of care, the plaintiff need only show that there was a foreseeable risk of some kind of personal injury, usually physical injury. That's Page and Smith. That will be enough. If they meet this test, the fact that they suffer unforeseeable psychiatric injury due to having an eggshell personality, if you like, will not prevent recovery. Of course, they've got to go on and satisfy the other elements of a cause of action and negligence: breach, causation, remoteness. Secondary victims. A secondary victim is a person in the position of a spectator or witness, a bystander to an accident, someone who's not in the range of foreseeable physical injury, not in danger. They need to prove an independent duty of care owed to them by the defendant. They cannot coattail on the primary victim's duty of care owed by the defendant. Any secondary victim seeks to recover pure mental injury in the UK must show that they've suffered a recognisable psychiatric injury. That's true for all victims. To establish a duty of care, they must show that they are at foreseeable risk of psychiatric injury and that it's reasonably foreseeable that psychiatric injury could be suffered by a person of ordinary fortitude or susceptibility. So if the plaintiff has an eggshell personality, but a person of normal fortitude would be able, we think, perhaps, to withstand the events without suffering psychiatric injury, that test will not be able to be satisfied and they won't recover unless the defendant knew of their vulnerability. Generally speaking, there has to be an accident, defined in Paul as an external traumatic event which causes or has the potential to cause injury, at which the plaintiff is present. And then they must overcome the 3 Wilberforce hurdles in McLaughlin and entrenched in the Alcock case. Relational proximity. Certain relationships are presumed to be having a loving relationship. Others have to be established by evidence. There has to be physical proximity. There has to be close, the plaintiff has to be close in time and space to the accident or its immediate aftermath. It seems unlikely that that's going to be stretched more than a couple of hours. As in McLaughlin, that seems to be the margin of time. And I would cite Alcock and Paul in support of that. Direct perception of the accident is required, and as the cases suggest, it's open whether, if you discover by means of social media, something like that, whether that equates to actually being at the accident and is sufficient for the purposes of direct perception. And remember that in both types of cases, once a duty of care has been established, you've got to go on and consider the other elements of the cause of action and negligence: breach, causation, remoteness. Okay, that's the UK position. Give me a minute or two and I'll get my slides up for the Australian cases, New Zealand cases. So for the rest of today and tomorrow, we're going to be looking at the position in Australia, Canada, and finally we'll come to New Zealand. And we'll stop perhaps a bit early today. I'll just introduce you to the Australian position and we'll look at the Annette's case and then we'll break. So, the Australian position. The leading case there is a case called Annette's or Tame, a High Court of Australia case. Now, the High Court of Australia is their equivalent to our Supreme Court, the British Supreme Court, their highest, their apex court. The Australian position is much more straightforward than the UK. They have adopted the rule, like Britain, that it's necessary to have a recognisable psychiatric injury. But in terms of what's required to show a sufficient relationship of proximity for duty purposes, they have dispensed with all of the other elements and requirements and simply apply the usual test for a duty of care in negligence of reasonable foreseeability of psychiatric injury. So there are no special rules for recovery of psychiatric injury. It's treated the same as other personal injury, notably bodily injury, physical injury to the plaintiff cases. They have dispensed with the distinction between primary and secondary victims. This normal fortitude qualification of the remoteness rule they have rejected, as with those proximity requirements from Alcock of relational proximity, physical proximity and means of communication. Years earlier than the Paul case, they dispensed with the sudden shock requirement. So that essentially they look at each case on its own merits and say, should a duty of care be owed on the basis of reasonable foreseeability of psychiatric injury? That doesn't mean that the Alcott factors are completely irrelevant. They're treated as relevant to that key question of whether there is reasonable foreseeability of psychiatric injury and to causation and remoteness. But they are kind of indicators, they are not determinative. So, this is the key case in 2002. And it was two appeals heard together. The first case, the Annette's case, the facts happened in 1986, and it took all that time for it to work its way through the court system to the High Court of Australia. It's a terribly sad case. In 1986, the plaintiff parent's 16-year-old son, James, was employed on a remote cattle station in Western Australia. Prior to sending him, the parents sought an assurance from the wife of the owner of the cattle station that he would be closely supervised and he would be cared for at all times. And it was only on receiving an assurance of that fact that they agreed to send him and let him go. He was assigned to work at a very remote part of the station. He went missing in December, and the parents heard from a policeman a few days after he went missing. They're in New South Wales. They went back and forth between New South Wales and Western Australia to help search for him over a number of months. His body was finally found in April. His father was shown, his bloodstained hat was found, his skeleton was found. His father was shown a photograph of a skeleton for identification purposes. I don't know how he would have identified him. So, terribly sad case. The parents are suing for their psychiatric illness. The facts of Tame couldn't be more different. In this case, a police sergeant accidentally made an incorrect entry of Ms. Tame's blood alcohol level on a traffic accident collision report. He mixed up the other driver, his blood alcohol reading, and entered it as Mrs. Tame's reading. She was not, in fact, affected by alcohol. The error was discovered within a month and it was corrected. But a year later, Mrs. Tame, having become obsessed about this, suffered a psychotic depressive illness for which she sued. So, just a few points. The High Court of Australia allowed the parents' claim for mental injury, notwithstanding that the harm they suffered was a result first of what they were told about their son's impairment and later death, rather than their direct perception of it. And they swept away the reasonable fortitude precondition and the sudden shock rule. This situation developed over a period of some 4 months. It wasn't a sudden shock, but that did not was not a barrier to recovery. They didn't. They also rejected the direct perception requirement, the second element of the Lord Wilberforce elements from McLaughlin, and said that the Alcock requirements generally produced arbitrary outcomes. They were capable of excluding meritorious cases. They weren't irrelevant, however. They were relevant to assessing reasonable foreseeability of psychiatric injury, to the question of causation and remoteness, but they weren't themselves separate rules or requirements. They weren't decisive of liability. The sole requirement is reasonable foreseeability of psychiatric injury for both primary and secondary victims. Look, actually, that's a good place to stop, and we'll stop there today, even though it's 5 minutes early. And I'll see you tomorrow, where we will finish the High Court cases, look at Canada and New Zealand. Cheers. Hey. Good, thanks. There you go.